Joining us now is someone who knows these things. Dahlia Lithwick, senior editor and legal correspondent for Slate. She's also the host of the Amicus podcast. Dahlia, it's great to see you. Thank you so much for being with us.
It's good to see you.
Is there anything that we've been talking about you tonight that has been like petting a cat the wrong way for you, that you feel like we have screwed up, got the wrong way around, or misunderstood?
Not at all. I might quibble with Ari's destination wedding metaphor, only because to me, it felt so acutely like that train in Speed, where it's just hurtling from one crisis to another. We have a court that's in the midst of a legitimacy crisis. We've got a Dobbs leak. We've got a bad investigation of the Dobbs leak. We've got ethics scandals left and right. We've got the first justice asking questions, had his wife texting Mark Meadows and trying to get state election officials to change votes. All of that is happening, and you sort of feel like the justices are like hurtling their bodies against the sides of the train, just being like, get me off this train. I don't care what the rationale is. I'll go with the one state shouldn't decide rationale. I'll go with the office rationale. I'll go with there was no due process for the president rationale. I don't care. I need to be off. And that like anxiety was palpable.
Yeah, and Ari is saying, that's exactly what I mean about that.
Right, so that means that whatever way, they weren't going to go to the wedding.
Yes, exactly.
Not going to the wedding.
The train isn't going to end well. Okay, so Dahlia, my question is a non-lawyer question for you, which is, I think that we could all see the justices trying desperately to get away from having to do something substantive here that would address the crisis at hand. What's the damage? What's the risk? What's the potential negative consequence of them finding a way to dodge it?
I mean, I think at the most sort of high-minded constitutional level, it's that this needed to be answered. And that is, I think, what Colorado was saying, is it is your job to resolve a constitutional question largely of first impression. It is your job to decide for this entire country whether or not the 14th Amendment, Section 3, is self-executing, whether the officer dichotomy holds, whether we can allow insurrectionists to run for office or not hold office. There was a bucket of questions that are exigent questions, and the court, I think, made pretty plain that they'd rather, or at least I counted, I think, 5 or 6 votes, rather hang their hats on this kind of dopey, pragmatic argument that, you know, we don't want to decide because it will allow shenanigans in other states. So it just seems to me that the downside is, and this was everybody knew this was a really huge vehicle. It was a big, big swing case, right? They have an opportunity to do the little swing when they get the immunity case, and maybe that's the trade-off here, right? But this was a huge swing case, but we have an unresolved constitutional question, and I'm not completely certain that writing, we need enabling legislation gets them out from under that question.
On that point about the immunity case being right around the corner, we expect that by Monday, these same justices will be asked to rule in, to weigh in on whether or not that D.C. Circuit Court ruling should stand, the ruling that says unanimously by that panel of appellate judges that President Trump doesn't have absolute immunity, that he can be prosecuted in federal court for what he tried after the election. In discussing immunity today, I guess he wasn't trying to bring up immunity, but President Trump's lawyer awkwardly brought it up with Brett Kavanaugh, while Brett Kavanaugh was trying to focus on this question of why President Trump wasn't prosecuted for insurrection. And we've been talking about that a little bit tonight, this idea that because Trump hasn't been charged specifically with insurrection, that suddenly seemed to create this incredible clarity among all the justices that had that thing happened, then this would be something where there would be an easy answer and we'd know what to do and this would be settled in some very definitive way. I wanted to ask your reaction to that. It doesn't seem clear to me why it's necessary for Trump to be charged with or convicted of insurrection for the Constitution's ban on insurrectionists serving in office to be effectuated. But what did you think of how that part of it was handled today?
I was a little frustrated at how deeply disrespectful I felt that the court was about the process that happened in the Colorado trial court. There was a trial on the merits. There were, as you just heard, meaningful findings from that court. The notion that trial courts can't do this thing, determine whether there was an insurrection, or even worse, Rachel, the notion, and we heard this from the Chief Justice, heaven forfend, we would have to somehow determine whether there was an insurrection. Imagine if that fell on us. Yeah. And so there's such deep disrespect for what actually happened. And I think it dovetails with, one of the things that you all said earlier in your roundup, which I think is so important. We have a court that for, I guess, the first time in 20 years, found humility today, like institutional humility. We can't do a thing. This is the court that decides air pollution and water pollution and vaccine policies and is going to determine what emergency room doctors can do when there's an abortion patient and what the FDA can do. They can do all that stuff and they can't either determine what an insurrection is or defer to a trial court's definition. It's very, very weird in February of 2024 to discover humility.
Yeah, exactly. Results-oriented, as we have been describing. Dahlia Lithwick, senior editor, legal correspondent for Slate, host of the Amicus podcast, and my favorite person to talk with about the Supreme Court. Dahlia, thank you so much for being with us tonight.